Hey D&D fam, I'm Quick.
And I'm Lee, and you're listening to
Divas and Ducats. So what is a diva? I think divas get a bad rep, but to me, diva is all about the attitude.
As for ducats, it's your finances, your assets, Skrilla, guap, your coin. We're talking all things with the potential to affect your pockets.
And while we're attorneys by trade, we are divas by choice. Divas and Ducats is for edutainment purposes.
Y'all, we are not Series 511 or 703 professionals. This does not create a financial advisor or attorney-client relationship. The views expressed here are solely our opinions and the opinions of our guests.
It's just our opinion, y'all. Okay, divas, let's talk ducats.
All right, welcome back, D&D fam. We are glad to have you here. We have an exciting topic of our Diva docket today. We're talking about protecting your business. Mm-hmm. What's in a name?
What's in a name?
Apparently a whole lot. If you don't protect your things,
right.
I think there's a movie about that, right? The McDonald's, that whole fiasco. Yeah. So
music has been done that way too. So.
Yes. Yeah. So we are getting into intellectual property. You know, we talked about passion into purpose and those who want to be a little more entrepreneurial. So we wanted to get into protecting your things. But before that, wanted to let you know, Quick and I will be hosting the Black Wealth Summit. It takes place in Greenville, South Carolina.
First weekend of October
1st and 2nd. There is a virtual component for those who don't feel as comfortable. So you can sign up virtually and attend sessions or live. Both of those tickets are available on our website at a discounted rate. So you don't need a discount code. You could just go and get the discount. Right. Directly to our website, divasandducats.com. Again, there's going to be breakout sessions. There's going to be various replays. I think the virtual aspect has a virtual DJ. So it's going to be a lot of fun. Tons of just interesting topics on the money, literally. So
yeah, and I also like to say that for the golf fanatics out there, there will be a golf tournament as well. For those people that are coming in person, and like you said, if you're doing the virtual, you'll get to see our faces, right?
Yeah,
as the co-host. So we're super, super excited about this opportunity to talk ducats and finances. So yeah, for sure, go to if you're on Instagram or Facebook, you can go to our links and it'll have a direct link to where you can go to purchase the tickets directly.
All right, so let's get into it.
Today we have, I like to say, our attorney. She did our trademarks personally. Miss Paula Yost. Welcome, welcome, welcome. Tell them a little bit about yourself.
Hello, divas. So my name is Paula Yost. I am an intellectual property attorney, and so I have a law office in Mount Pleasant, North Carolina.
Okay. And so with that being in Mount Pleasant, North Carolina, are you only licensed to practice in North Carolina, or how does that work with the...
Well, I actually have 3 law licenses. So I have 1 license to practice in North Carolina. I have 1 license to practice in the state of Georgia. And then I passed the United States Patent and Trademark exam. So I'm also a federally registered United States Patent and Trademark attorney.
Okay. And that allows you to practice where?
So with that license, as long as your goal is to bring a matter before the United States Patent and Trademark Office, I can represent you no matter where in the world you are.
Okay.
So I have clients who are international. I also have clients in, I think, 37 states by my last count. So I'm not limited to a state line as long as your goal is that you need a federal matter, like a federal trademark, a federal patent, or copyright.
Okay.
What I heard her say was like, I'm not limited like the normal attorney.
Right. I'm taking a step further. Right. North Carolina, Georgia.
Get barred everywhere.
Right.
That's really cool. But I know it takes a lot of work, right? Like how did you know you wanted to become a patent attorney, or what is it required?
I absolutely did not know that I wanted to do this at all. So I was a senior at Virginia Tech when 9/11 happened.
Oh, wow.
And I had a really good mentor there. I was working in a lab, and I told my boss, like, I have no idea what I want to do. There are no jobs. Like, I just really don't know. And so I was completing that year. I was completing a BS in microbiology with a minor in chemistry, but I also had an English degree that I got basically just because it was easy and I liked it. Like, I didn't have to work hard to do this. And so my mentor or my boss at the time was like, well, you just need to go to law school. You can become a patent attorney. I didn't know what a patent was. I'd never heard of it before. I was like, what's that? But it turned out to be really good, like life-changing advice. And so I took the LSAT, I mean, maybe 3 weeks later. And then I went to law school the following August after I graduated.
That is so cool. And I know, like we've talked about it on other episodes before, but it's definitely like a good mentor can just like shift the trajectory, you know, of your life. Important. And then with the patent attorney, does she know your majors? Like, is there a requirement for you to have a certain major? Or?
Yes. So you can't sit for the United States patent exam unless you have a 4-year degree in a pure science, engineering, or math. Okay. So I used my microbiology degree to be able to sit for the exam.
Got you. Okay. And she said English was easy. I mean, I guess compared to formulas that have numbers and letters.
Compared to organic chemistry, it was easy.
It's a blast. Like, okay, we can read some Shakespeare, no problem.
Okay.
It's pretty easy.
Yeah, so I mean, I definitely know that was extra. I do, because I remember, and when I was in law school, that was the first time I had heard about someone, you know,
patent bar.
Yeah, and the requirement, because I was like, okay, maybe I was like, no, your major won't.
Not yours. Not yours,
no, boo-boo.
That's cute. You can do the other ones.
So, yeah, it's really interesting. So, for those out there that might be interested in, just make sure you have the right major undergrad. I think that's really interesting that requirement has not changed over the years. So
we are the super nerds of the legal field.
Right.
We're a whole other level of nerd.
That's how they let y'all practice across the United States.
Right. So for those who don't know, you know, you hear various intellectual property terms that are all kind of under that umbrella, right? So you'll hear copyright or trademark or patent, but many of us don't know the difference between the three. And so can you kind of maybe, you know, make a fifth grader understand?
Absolutely.
What are the differences?
So a patent is on an invention. It's actually on a product. So like how my iPhone works, like the physical nature of my iPhone, that is patentable. Okay. It's also, you can have design patents, which are on something's functionality. So the little cardboard bands that go around your Starbucks coffee in the morning or wherever you buy coffee, those cardboard bands actually had a design patent on them. There's a number on those. If you look for it, it'll say a little D, like the letter D for design, and then it'll have a 6-digit number. That is that thing's patent number. Trademarks are things like Nike, Tide, their logos like the Nike swoosh. They can also be slogans, like Lowe's has a great one, let's build something together. And then copyrights are on written material. Okay. So they can be on things like architectural plans, interior design plans, books, songs. They can also be on artistic pieces like paintings that you've created.
Okay. So like the Coca-Cola formula is a patent.
Correct.
Okay.
But Coca-Cola itself, the name is a trademark.
Correct. See, y'all are just applying that.
Look at that. Just applying the knowledge.
Okay.
So is there a difference between like a trade name and a trademark? I've heard that.
Not really. Okay. There, you know, we used to have all kinds of weird legal distinctions between stuff like that, and then like trademarks and service marks, there used to be differentials. There's really not anymore.
Okay. So now when you think of like the little TM you'll see by someone's name versus the R, is the TM like a common law trademark or is that something different?
No.
Okay.
So the TM, what it is really supposed to signify is that you have filed a federal trademark application before the federal government.
Okay.
So when I first filed Divas and Ducats, you guys were allowed to use a little TM beside of your name anytime you used it. But then once your brand actually registers, so once the trademark office completes their process of reviewing your brand and making sure that you're cool, then they graduate you, for lack of better terms. So that little TM becomes an R in a circle. Okay. Almost I bet you 90% of the people listening to this podcast, if you have anything on your body that has like a logo, like a sports logo or any type of college team or anything like that, you are going to see either a TM or an R in a circle because almost all colleges and universities and sports teams professionally have all of that stuff branded.
Gotcha.
So it's easy to see things like this if you know what to look for them because they're truly all around you. There's probably no one listening to this who doesn't have something with a TM or an R in a circle somewhere in their closet.
That's interesting. I would have never thought it would be on my clothes.
Well, I think you see it and just never really paid attention. Because I think before we got into, professional realm, I would see an R all the time and be like, oh, okay.
Well, yeah. But I guess I was like thinking about a shirt, like if, college shirts, you just think about the name of the school, but not, the TM. So speaking of the TM, since that's an indication that you've done something federally, like went and took active steps, should people be using TMs if they have not done that step?
I'm going to tell you that the answer to that is no, you really shouldn't be, because if you're using a TM on something that you have not actually trademarked, you're really misleading the public because what it is for is to make the public think you have putting the public on notice that you filed a federal application. However, I can also tell you that as of right now, and it would be September 3rd, 2001. The law might change, but as of right now, there is no penalty that happens to you if you're caught misusing the TM. However, don't do that with a patent. Because if you allege that you have patent pending or you allege that you have a federal patent status that you do not have, you can be fined federally, and it can be a steep fine. So you don't want to get yourself into some kind of trouble for misrepresenting what you have. But with a trademark, I mean, honestly, nothing's going to happen to you. But if you do that with a patent, you can really get yourself into a lot of trouble.
And so for patents, is that what they usually put, patent pending?
That's correct.
Just write it out?
That means you have a patent application that's, it's literally what it says. It's pending before the government.
Got you.
So is there a difference between like common law trademark and a registered trademark?
Yes, and that's very important and actually a huge difference.
Okay.
So common law trademark just means you're using a name. You started using it and, you haven't done anything with the federal government or a local state government in order to protect it. A registered trademark or a federal trademark, what that means is basically that you're paying the government to be the bouncer in the bar. That's how I like to explain it. Basically, you're giving the government a filing fee. You're telling the government, please approve my name. And if the government approves your name and says, no, we have proof this person is using this name in this class, and they've been using it since, whatever date you've started using it from, basically from that point on, the government is going to stand behind you and protect that name. So if someone else comes up, just again, like somebody tries to get into the bar and says, hey, I'd like to file a trademark on Divas and Ducats. The government is going to say, no, you're not, because that's already been taken. They're going to reject that under Statute 2D for substantial similarity, and they're going to tell you bye-bye. And then if I find out about it, I'm probably also going to send that person a cease and desist letter. So there's that. I do occasionally, I also like to explain it as like an insurance policy. So you spend a lot of money on your brand. Your brand is really, really important. It's recognizable. And so you don't want to spend all that time and money on getting your brand put together and then have the government come in or have someone else come in and destroy it because you didn't properly protect yourself. So a federal registration is the best way to move forward, saying, I'm putting the flag in the sand, this is mine, nobody else needs to infringe upon it.
Got you. So basically common law is it's not enforceable. So someone could just come take it.
Yeah.
It's like, oh, well.
Yeah, and they could beat you to the trademark office. They could file a federal application before you. And, as a general rule, sometimes people are like, yeah, I don't really think it's that important. I'm like, that's simply because you're not informed. Like, if you're informed about this and if this brand is really important to you, especially if it's something you're going to spend a lot of money protecting, you need to get some protection on it.
Yeah.
And that is the explanation of why, a lot of people think, oh, I'll just file my name with the Secretary of State. Mm-hmm. Because if you do business in a particular state, you just file it, whether it's an LLC or partnership, etc. And they think, oh, well, I'm good because in that state, they won't have anyone else under that name. But it's not actual... Right. There's no enforcement of your ideas or someone just literally stealing your things.
Right.
Sure. So because I'm also a federally registered trademark attorney, when someone calls my office and they say, hey, can you form a North Carolina entity or a Georgia entity for me, which I can do because those are the states where I have a law license, I always search the federal registry as well, just to make sure they're fine. Because I've certainly had clients I'll have a client who has a registration and they'll get some kind of alert on Google that somebody in Florida just formed a corporate entity with the same name as them. Well, I'm very quickly sending that corporate entity in Florida a little nasty note that says, hey, you can't be using this name. And I have a whole paragraph that I put in there that specifically states, I understand that your state allowed you to form this LLC, and that makes this very confusing. Right. And I recognize that you probably are not educated about federal trademark law, but if you proceed with this name, that is trademark infringement.
Mm-hmm. And does it matter, if it's a similar business?
It does.
Okay.
It matters a lot. So the trademark office has 45 different classifications that you can use to protect your name. Okay. So the best way for me to explain this, you might be able to go and open up a shoe store and call it McDonald's, but no way on God's green earth are you going to be able to open up a restaurant. Okay. And if you try, McDonald's attorney is going to send you some hate mail eventually once they find out that that's what you're doing. So it is very, very important.
Gotcha.
Okay. And so how does one protect themselves without, because obviously each category is a cost. There's a fee per category.
There is. That's a very good point.
How do you protect yourself, say it's not confusing to the consumer, but just the name alone, McDonald's. But, they know it's a shoe store. So, of course, they're not going to confuse it with the restaurant. But, I would think that McDonald's would want their name, don't use it at all.
So that's a really good point. So what the government has said is you can't just globally, no matter how much money you have, you cannot globally purchase a trademark in all 45 classes. Okay. You have to actually eventually show use. So eventually, if McDonald's didn't want people to form shoe stores and call them McDonald's, they best have a trademark in the sale of shoes. Okay. And they don't. So, because that's not what their business is. Right. I've had shady people call me before and say, hey, I had this really bright idea and I want to buy this domain name and I want to buy this trademark because someday they're going to be valuable. And I'm like, well, are you selling products? Are you offering services? Well, no, I just want someone else who wants to sell products and services to buy this name from me. Well, you can't do that. That's not how this works because eventually you have to show that you are using that brand name for the intended goods and services associated with it.
Gotcha.
And so to that point, because I know people sell domains, so they sell their trademarks too?
People can absolutely sell a trademark. I have licensed a trademark for 5-digit figures in the past. I've had people buy my clients' trademarks. So, yeah, they can be really, really valuable. They can also make your business appraise higher. Okay. So, if you've had a trademark that, you've had it federally registered for many years and you go to get your business appraised because you're ready to retire, it actually can make your business appraise at a higher rate because then they assume that your business has been well protected. It has brand following. So it really does help your business be more valuable.
And so then speaking, like you were saying about the person, that was in Florida, you had a trademark and then the person in Florida, they were able to file with the Secretary of State, but now they're getting this cease and desist letter. So why isn't filing with Secretary of State enough? And then a person that is filing a business with the Secretary of State, how can they search to make sure that, there isn't a trademark under that name?
So it's not enough to simply file with the Secretary of State because they are not searching federally. Okay. They are here for one reason and one reason only, to get money for the government. That's what they're here to do. They're here to collect your money. They're also here to make sure that there is not another business with that identical name in that state. Beyond that, what you're doing is not their problem.
Gotcha.
Okay. So some of my clients flag like Google searches so that Google will tell them if somebody, buys a web domain that's similar to theirs or starts something. You can also have intellectual property attorneys. Like I have software where you can pay me additional funds and I can be like a watchdog for you. So I can search all through everything, and anytime anything on your brand comes up, I will get a monthly report that will tell me if there's anything that needs to be taken care of. But it's pretty expensive to do that, and so I always like to talk about expense too, because a lot of people just go nuts. They're like, I want to trademark this name and, I'm selling 75 things and I want to trademark it and all this stuff. And I'm like, just to be straight up with you, are you Martha Stewart? How much money do you have? Right? Because Martha Stewart has her name trademarked in like 45 classes, but she's doing business in all of those things. I mean, she is doing that. She is incredibly successful and she has a tremendous amount of money and she doesn't want people copycatting her. So, if you've got the money to do it, I would love for you to contribute to my children's college fund. I assure you, I'm here for you. But the average small business owner can't afford to do that. So what I typically tell them is, what is making you the most money right now? Okay, if you're selling 57 spa items, but candles are where you're making the most money, why don't we trademark candles? And then when you're making more money down the road, we can file a new application and add some classes to it. But I think people always need to start somewhere, and you should try to start with whatever is the actual focus of your business. Like a lot of times too, people will come to me and they're like, well, we're going to sell merch. I'm like, okay, well, how much money do you think you're going to make off this merch? And they're like, I don't know. And I'm like, again, are you Green Day? Are you REM? Are you some brand that people want to listen to and hear about and know? Okay, that makes sense. But it doesn't make sense to trademark your merch if all your merch is really doing is attracting people to what your business really is. Right? So you have to be really mindful of that. But I'll straight up tell people, this idea is not going to work because of whatever reason, and I'll redirect them to what I feel like they need to do.
Got you. So talk a little bit about the process. Like, how do you go to file for that protection? Maybe like how long does it take?
Yeah. So the first thing is that you have to file with the federal government via the United States Patent and Trademark Office's website. So their website is US, like United States, PTO, like Patent Trademark Office.gov. And that's where you go. I will tell you, though, that website changes all the time on like the whims of what the government feels like. I'm on that website literally multiple times a day, almost all day long. I mean, I pull over on the side of the road sometimes and look at that website for various things that I need for clients. So if you're not experienced with the website, it can be very difficult to figure out where you are and what you need to do. But basically, I file trademarks. This is my personal policy. If a client calls me up and says, hey, I want to file a trademark and this is what I want to do, I try to do that for them like that day. Like I try to do it within a 24-hour time period. Because once I have filed the application, again, that would be like your little TM status, that does give you some federal protection. Because that's kind of like you put the flag in the sand and you said, this is what I'm doing, I'm ready to go. So that's really, really important. So I don't want people to have to wait on that. But then absolutely no one in the government is going to look at your application for 4 to 6 months. Because what happens over that time period is it's just kind of sitting in the government's bin. There is absolutely no way for me to expedite a trademark. Again, it does not matter who you are or how much money you have. I cannot give the government enough money to make them expedite this. They will not do it. So they have one trademark office. It's in Alexandria, Virginia, and it services the entire country. So yeah, there's a 4 to 6 month wait. Once it is assigned to a trademark examiner, usually one of 3 things will happen. A best case scenario, and I have done this before when I've really been on point with my job here, is the trademark office says this application's perfect, and they just move you right to publication and registration. And I don't have to do anything else. You just slide right on through. It's great. It's beautiful. Other times, the trademark examiner will call me. If you're represented by counsel, they're going to call your lawyer and not you. I mean, of course, I'm an attorney and I'm biased, but that's probably what you want.
We appreciated that.
Because I know what they're talking about, right? And if they ask me something, I know how to answer that. You know, this is old hat to me. I've been doing this for 15 years. I've filed 500 trademarks in private practice successfully, so I know what they're saying. So sometimes I can resolve any outstanding issues that the examiners have in a quick phone call or two and move you on along to publication and registration. Other times, we might have an office action. So an office action can consist of all kinds of stuff. People who are unrepresented by counsel, sometimes they do fine until they get an office action. But the office action is really where they're like a deer in the headlights. Like, they're like, I don't understand what this is. I don't know what it means. I don't know what to do with it. And so a lot of people wind up hiring me at that point because now they have this thing, but they don't know what to do with it, and they don't know how to move forward from here. Office actions, again, I see them all the time. I respond to them all the time. There are some that are pretty challenging, but I try to minimize them from being challenging by searching your brand in the first place. So if I search your brand federally in the first place and I'm like, I don't know if this thing is going to register or not, I will tell you that. And I will tell you there's some other things out there that scare me, so I'm not 100% sure we can get this thing to happen, but I'll tell you like my good faith effort in whether I think I can do it or not. I've told people in the past, and I will also tell you if I think that you are going to get sued if you do this. Like, I've had clients before who I've said, I would love to take your money. However, if you file this trademark application, you are going to get a cease and desist letter from the person who actually owns this name and who trademarked it however many years ago it was. So I try to just be really, really real. And that's important too. If you are seeking a professional to work with on something like this, you want to have somebody who will tell you that.
If it's, what is the term? I don't know. I might be mixing up with something. Is it like significantly similar or like overly broad?
Very, very close.
Like
The key term is substantially similar as to be unduly confusing to the average consumer. What that means in English is if I am walking down the hallway in Target and I see your product in beauty and cosmetics, and then I walk down the cleaning aisle and I see a cleaning product that has the same name, am I going to think they are both owned by the same company? If I think it is the same company, that is substantially similar as to be unduly confusing, because I, as the average consumer, maybe I'll really like the product in the cosmetic aisle, so I'm going to be more likely to buy the same product if I see that same brand in the cleaning aisle.
Support,
Exactly. It's brand support.
It made me think when you were saying that, it made me instantly think about Martha Stewart. Like, you'll see her stuff.
You're like, it's Martha Stewart. I'm going to buy the towels and the bowls.
Exactly. That is how it works.
And so when they're in that process, because I know even with ours, like, there was some pause and you had to, work your magic. But one,
clarity was needed.
Right.
I worked it though.
Right, we didn't have to deal with anything. So, one, I will say, before we even started, like, talk about the people that, are just starting their business and don't really have any product to show. But wanting to jump ahead and get a trademark. How does that work?
So there's two ways that I can file a trademark in our country. The first one is called Statute 1A, which means use. That means I am actively using this brand right now. Here is, here's my website. Here's a picture of my brand name on the front of my candle. This is in use. That is Statute 1A. The other way to do it is Statute 1B. Statute 1B says, I am not using it yet. However, I intend to, and I also am planning to spend some money on marketing it. So I really want to go ahead and put my flag in the sand that says I'm going to use this. The only thing I don't like about Statute 1B, it's perfectly fine to file something under Statute 1B. The only thing that I don't like about it is that after it registers, so before it registers, after it publishes, so after the government evaluates it and, whatever magic I have to work is done and it publishes, then the government issues something called a notice of allowance. And when they issue that, then you have to produce a statement of use. So then you need to produce your, evidence of use. The only thing I don't like about doing it that way is you have to give the government more money. The government either requires a $100 fee when you show use, or you can purchase extensions of time that are $150 and you can purchase 5 of them. So essentially you can extend it for up to 3 years as long as you're filing extensions of time. I'll interestingly enough though, y'all can probably tell from my country accent, I was raised in the middle of Datburn nowhere. And I'm a first generation college student. Neither one of my parents went to college. My mom actually has a GED and my dad worked in a cotton mill. So I was raised on people who, my dad made $13 an hour when I was, and that was in the 90s. So of course, relevant to today's, it's stretched further. But I'm not a person who grew up with a lot of money or with a wealth mindset. So I get real freaked out. I'm like, God, don't give the government an extra $100 if you don't have to. And some of my clients are with me on that. They're like, yeah, don't do that. And I have other clients who look at me like I'm insane. They're like, $150. Yeah, they're like, I wouldn't pick that up if I dropped it on the floor, right? And I'm like, okay, I'm just here to tell you what your rights are. So the only downside to doing a Statute 1B for intent to use is that it's a little bit more expensive, and how you defined expensive, I guess, is all relative.
Yeah.
And once the, government comes back, and do they deny or approve?
Yeah.
Can you appeal?
You can appeal, but goodness, I don't want to do that because appeals are super, super expensive. And if I really think your examiner is wrong, the trick that I have to get around that is I just refile your application from scratch and get it assigned to somebody different. That's how I fix that problem, because it's cheaper. It's genuinely cheaper for me to just start the whole darn thing over from scratch and get it to register that way than it is for me to try to fight your way through an appeal. That's expensive. It's frustrating. Nobody benefits from that but the government. And so I really try not to appeal things. But it is an option. It's just not a very good one, in my opinion.
So when we're talking about costs, what, and I'm not sure if they're different for copyright, because I know we've been talking a lot about trademarks, but what are the costs associated with filing?
So there's 2 costs associated with filing, and it's all based on how many classes you're using. So if you are just filing in one class, the government has what they call the least expensive way, where you can only pay $250 for the filing. But I will tell you, my experience with that is that all that does is highlight the government to find things wrong with your application so that they can then bill you the extra $100. And it just makes everything more, I feel like trying to do it the cheap way causes your application to be scrutinized in a way that I don't appreciate. So I just make all of my clients, we're paying $350. That's what we're doing. You might find another attorney who's perfectly fine doing it the cheap way. I'm not, because it's going to make your life and my life more difficult. That is a time when I have less problem giving the government an extra $100. Sometimes I really don't want to do that. That's a time where I'm like, it's worth it to make them leave you alone. So it's $350 per class. So that goes back to what we were saying about Martha Stewart. If you're in a whole bunch of classes, this thing can get pretty expensive pretty quickly, right? As a general rule, what I do is I flat rate all of my fees. So I usually just charge a flat rate attorney fee. I don't care how many classes you're in. It's pretty much the workload for me is not terribly different. So I think the range for how much these things cost, because I don't want to just speak for just what I do, because you can use an attorney anywhere. These things can range from anywhere from $1,200 up to $2,000 to $3,000. It really just depends on who, like what professional you're working with and how they choose to do things. Like some attorneys want to bill time per hour to do this. Other attorneys just want to do a flat rate package deal.
Right.
As a general rule, I tend to gear my business towards small business owners. So I tend to do a flat rate package deal, but there's some people who don't like it that way.
Right.
So, I mean, it's just kind of what is in the discretion of the professional that you want to work with.
Got you. And
But it's not cheap.
No, it's not.
It's not
but
cheap.
it's worth it.
It's worth it.
Now, for those who are in more of like a creative space, I guess, like the copyrights, are the costs similar there?
Exponentially cheaper.
Okay.
Much, much, much cheaper.
Okay.
Copyrights are only $55 to file, $55 to $65 to file. It just depends on like what you're actually filing it on.
Okay.
And then the attorney fees are way cheaper because it's way less work.
Gotcha.
Usually you can probably get a copyright for less than $1,000. I have had the occasional client who is a photographer or an artist who's really generating a lot of potentially copyrightable product. And I don't want them to have to pay me an egregious amount of money because they're copywriting like hundreds of the same thing. And so I have actually had those types of people. I will teach them a class on. I make them hire me and pay me like a one-time upfront hourly fee. I teach them how to go on the Library of Congress's website. So it's a different website. It's not the USPTO.gov. It's actually the Library of Congress's website. I have them go on there to the Copyright Office. I have them set up their own account, and then I walk them through how to create their own template online. So then all they have to do when they create stuff is go into the template I helped them make and then reload the same, whatever it is that they're filing. They don't have, it's so easy to do it that way. And it's easy on my end too, but it's too expensive for them to use an attorney to do that every single time. And it's something they can completely do on their own. They just have to have somebody teach them how to do it.
Right.
I think that's awesome.
So that for that person that's constantly writing songs or poems or what have you, they can kind of just keep going in there. And
Absolutely. They can just go in there, and I build it all out for them so they know what everything is. And then they basically just have to click on their template and then complete the last steps repetitiously.
And so, I mean, to that effect, like, so, I mean, I know people don't really put out albums anymore, but so the song list that's in an album, each song has to have a copyright?
That's the best way to do it. Yeah. And I mean, you can file compilations where it's like, all of an album can be on there, but certainly if your plan is to release like a single, then I think it's always in your best interest to copyright the lyrics to the single.
And so how does it work? Because right now I'm thinking like wedding photographers. Do they have to copyright like each? Like, how does that work for them?
No. So that's a really good question. So if you are a photographer, usually what you do, you don't need to federally copyright that because, I mean, like my wedding pictures, I don't think are important to anyone but me and my family, right? Like nobody else really cares what my wedding pictures are. They're not valuable. Now, if I was Angelina Jolie, maybe people would care, but nobody cares about my wedding photos. Like absolutely no one does. So they don't have to do that. That's just a simple contract that a photographer can have that basically says, you pay me X amount of money and then these pictures are yours and you can do whatever you want to with them. That gets into a more complicated space though, if the photographer is really famous or a really big deal, or if the person they're taking a picture of is a really big deal. It can also be a big trademark issue too. Like, if a famous photographer's taking pictures under their name and then some 22-year-old shows up and tries to redirect you think you're hiring famous person and you're hiring some kid who just graduated from photography school. There's certainly a reason there to trademark your own name too.
Got you.
Yeah, because I guess I just think about like in the social media space, some of these photographers have, almost 1 million followers.
Amazing.
And then people will share their picture as if it's their own page, So I just wonder how they protect that if it's not.
So that also deviates from trademarks a little bit, but that's also something I really like to tell business owners is that you really do need to think about what you're putting on your website. I'm not so much worried about your social media because the government really hasn't caught up to policing social media. But on your website or on your blog, please don't post a picture unless, number one, you took it yourself. Number 2, you paid a photographer to take it and you own the rights to the picture, like I just described with wedding photographers. They signed it over to you. Or number 3, you purchased the image on a website like Getty Images or PicScout or somebody, and you actually have a license for that picture. People get harassed, like absolutely harassed, by copyright trolls. That's going to sound weird. A troll, I'm literally saying like a troll under the bridge, like you would read about in Grimm's fairy tales. And that's not a term that I made up. That is an actual legal term of art. If you Google the terms copyright trolls, this will come up on Wikipedia. And it's actually a really solid Wikipedia explanation of what a copyright troll is. Basically, they're a debt collector, and they comb the internet to find small business owner websites that have pictures that were taken by some other photographer that have a federal copyright attached to them, and then they send you a bill. I've had clients who have gotten invoices from these people that were like $30,000 to $40,000 to $50,000, and so that is like a crap your pants type of a day. Like you do not want that to happen to you. So please be very careful about what you put on the internet. Make sure that it is something that you own the rights to.
Some good information right there.
It will get you into trouble.
Right.
Big trouble.
And so they're also keeping on the social media. I know we were talking more so about like common law trademarks. If a person, like that's all they have is their common law trademarks, can they not use like the use, like I've been doing this for 5-6 years, and I've published it, and everybody knows me as this.
Is their presence is enough, or does it just show like use?
It's really not enough. I mean, it just proves use. Let me really explain why this is helpful with social media, why the federal registration is helpful. So with social media does not do a very good job of making sure that people don't have the same name.
Right.
They don't.
No.
They don't. Like
_1.
Yeah, change a character, whatever. Right. Social media does not do a good job of policing that. They're kind of like the Secretary of State. They don't. That's not their problem. That's not what they're here to do. So then what happens is if you have competing businesses that have substantially similar as to be unduly confusing names up there, then you get into problems when the consumers get confused. So, for example, early in my career, there used to be a store in Gaston County. It was just a storefront, and everything with the storefront was fine. They had a common law name. They'd been using this name for a really long time. They were good. Everything was fine until they started selling monogrammed baby blankets on Facebook.
Okay.
And so then what happened was there was a store with not the same, but almost the same name. And in Wilmington, Delaware, a woman showed up furious because they did not have her baby shower baby blanket ready, and that shower was in an hour. And it wasn't done. And they were like, we've never heard of you. She whips her cell phone out and says, look at this order right here. And they look at the Facebook page and, oh, no, that's not the Wilmington, Delaware location. That's somewhere in Gaston County, North Carolina, and we've never heard of these people. We have no affiliation with them. We don't know that they exist. Ma'am, this is your fault because, you should have checked what state you were in. But they sent those people in Gaston County a cease and desist letter. And the other thing that they did is they had the Delaware company had a federal registration, and now they can prove brand confusion because that is absolute evidence of brand confusion. So what they did, they sent Facebook their federal trademark registration, and they shut the page down. To be honest with you, and I feel so mean when I say this, I feel like the Grinch who stole Christmas, but I shut down social media accounts all the time. I really do, because I'll have a client who has a brand, and then somebody else does exactly what I just described. They think it's a brilliant idea, and it's never happened before, and they try to do it themselves, and they get an Instagram page, and all of a sudden my client's like, whoa, that's my name. Right. And so I will upload those names to the trademark office, or I'll upload those names to Facebook or Instagram, and Facebook and Instagram will shut your social media down in 24 hours. But I want you to really think about that. Okay? So that's not a big deal if you've been up for 5 minutes and you have, maybe 50 followers. But if you are an influencer, I mean, if you've got 300,000 followers in that space and all of a sudden it gets taken down because you don't have a trademark and somebody else does, that is a sad day. And so you really do want to be mindful of stuff like that, because you can get too big and be unprotected and get yourself into problems.
That's true.
And in that situation, because I know you mentioned earlier that you have like software that you can use to constantly be searching for if someone else is using your name, but how would a person that is not represented by an attorney have that kind of protection?
I have no idea other than Google.
Okay.
Because it's expensive software. I mean, it's even expensive for us, which is why if a client wants me to watchdog it, it's expensive because I have a lot of expense to me to even own that type of software in the first place. Yeah. So it is very expensive. But Google is your friend. I mean, you can find out a lot by Google and setting alerts and stuff like that.
Is there a search on the U.S., is it PTO office? Is it the same way that it is Secretary of State where you can search a business name? Can you do that on there? Okay.
Yes. It's called the TESS, the TESS.
Okay.
And so you can go on there and you can search for things. But so a couple things about that, because people get themselves in trouble though when they don't know what they're doing. So the government doesn't care about things like spaces. They don't care about hyphens. They don't care about whether it says and or whether it's an ampersand. They don't care if it's the number 2 versus TWO. They don't care about stuff like that at all. What they care about is this name substantially similar as to be unduly confusing, and is there another name that is the exact same thing? And if the answer to that is yes, then you have a problem.
Well, protect the name, y'all.
Yeah.
That's all we can tell you is protect your business.
It really is. I think, Quick and I, we say all the time when we talk to, whether it's small business or other entities in terms of development, like we always say that our story, we want it to be protected before we even record it. Like we were just, I don't know, I guess it's the attorney in us. We were just like, no, we're going to have everything together because we don't want someone to come and take it. And I am very candid about the fact that Quick vetoed several names before I was able to come up with Divas and Ducats. And I was like, oh, we're not going to do this again. Like we need to be good. And I think, like we said, we spoke to Paula, like this is what we're trying to do. These are kind of the areas that we're in. Like, what do you think? And, even that, like it's funny now, but we were like afraid to record a show. Like, well, we put a show out there. Is somebody going to steal it? So just really look into, she said that, for you, Statute 1A, 1B, either way, just look into getting protected as soon as you can. And it is a cost. It is a fee. We've been over it, but it's worth it. It's one of those things that I would say maybe in addition to like, getting your taxes done by a professional, that cost as a small business is worth it. Yeah. So.
Yeah, definitely. I definitely think it's it's just needed, especially like you said, if you actually have a following, if you have clientele. If you're starting up your business and you're going to be in more than just your city. Yeah. We on the airwaves. So just it's so important. Like it just you might think that cost is so much, but like she's like, Miss Paula said, it doesn't compare into the cost of how much you put into your business and then having to have it shut down. Right. And start over and then trying to bring your clientele over to some, we don't know you as that.
Or having to change your name.
Yeah,
right.
Having to change your name.
Who are they?
So, as Tina Turner said, I just want my name. Just keep my name. It's something in the name. So that's what the Divas have to say to you, Miss Yost. We're telling you to protect your name. Reach out to a trademark attorney. Where can they find you at?
So the easiest way to find me is on my website, which is www.country, like I work in the country, because I do, law, LAW, like I am a lawyer, and then shack, SHACK.com, like Love Shack or Crab Shack. Also, on that name, people ask me about this all the time. People either love my name or they hate my name. And I'm like, here's the deal. nobody is going to remember the law office of Paula J. Yost.
Right.
Because that is a dime a dozen. That is just somebody's name. Nobody's going to remember that. But the Country Law Shack,
Can't forget it.
people will remember that name, and they will love it or they will hate it. But if you love it, then you probably belong with me.
That's right.
So,
Wait, is it actually a shack?
no, so that is a good question. It used to be. So I inherited my great-grandma's house in 2012, and when I got it, it was a shack because it looked like an episode of Hoarders when I got it. But it is not a shack now. I've made it nice now, but it was when I got it.
Gotcha.
Well, we have really, really enjoyed all of the wealth of information that you've passed along, and we are always eternally grateful every time we look at our logo.
Yes.
Think about you.
And our R. So if you try, go get that
Don't even
Matumbo letter.
try it. So we just appreciate you on here and helping our Divas and Ducats family. And Lee, do you have anything else?
I don't. We've told you about the Wealth Summit.
Yeah.
I think real quick, definitely look into starting your little savings for your trademark or copyright for those who are doing things. And
yeah, for sure. And if you are watching us on YouTube, why have you not subscribed? If you have not subscribed, hit the button below. Make sure you're following us on Instagram and Facebook. We thank you for always tuning in. And in the meantime, in between time, have a great attitude.
all right, bye.